Hi, I'm Omar Khalil. I head up the legal team for EEF's key accounts. EEF provides HR and employment law support services to a variety of businesses in the manufacturing sector. Employment tribunals is one of the most feared and costly aspects which a business will need to deal with. The preparation of dealing with the tribunal is key to its success. Employers can avoid employment tribunals by adherence to policies and procedures, and if you are going to depart from established protocol, have a clear and reasonable explanation for doing so. In addition, keeping paper trails of your decision-making processes is another fundamental aspect of protecting yourself. However, it is important to be guarded rather than casual in written communications, as these are likely to be viewable by employees if they put in data protection requests to see their personal data. If a tribunal goes badly, there are important consequences. The main claim which employers face in the UK is for unfair dismissal. The compensation payable for an unfair dismissal claim can be up to a year's gross pay, or £80,000, whichever is lower. In addition, employees can claim something called the basic award, which is calculated in the same way as a statutory redundancy payment, and also, if they haven't been given notice of termination, they can claim a payment in lieu for that. It is also important to remember that discrimination compensation is uncapped. It has no limits. For some employers, the financial compensation is not the most significant aspect of defending an employment tribunal. It is instead the management and human resource input that goes into defending the claims, which significantly outweighs the financial consequences. And for other employers, it is the adverse publicity which they fear, particularly in discrimination claims, as that can lead to reputational damage, which is fundamental to them, particularly if they want to be an employer of choice. Witnesses who appear in an employment tribunal for employers can be expected to be subjected to a significant degree of scrutiny by the employment tribunal, by the employee or their advisors. As someone who has appeared in many employment tribunals and in the county court, the degree of probing and inquiry which a tribunal subjects the witnesses to is far greater than that which is experienced in the county court. Witnesses need to be able to withstand this degree of scrutiny. It is often said that a good witness can make a case and a bad witness can break a case. At EEF, we can help employers and the witnesses prepare for an impending tribunal claim. We run a mock tribunal, whereby we reenact a real-life case with anonymity. This gives delegates an insight into the terminology, the structure and the procedure for the day. At the end of the day, we issue a mock judgment to make the experience complete. Recent employment tribunal decisions have made it clear that there should be a separation between the HR function and managers who have responsibility to decide on grievance and disciplinary cases. It is important for the two not to be conflated, and if there are internal communications between HR and management, these ought to be carefully worded as they can be disclosed. In another employment tribunal case, the tribunal has made it clear that when an employer receives an occupational health report, it should not simply take it at face value. It should carry out its own further inquiries of the employee before it makes its final decision. For more information on employment tribunals, please visit eef.org.uk/employee relations.